Exempting circumstances. 1. Definition. Exempting circumstances, non-imputability, are those grounds for exemption from punishment, because there is wanting in the agent of the crime any of the conditions which make the act voluntary or negligent. 2. Basis. The exemption from punishment is based on the complete absence of intelligence, freedom of action, or intent, or on the absence of negligence on the part of the accused. Under the Revised Penal Code, a person must act with malice or negligence to be criminally liable. One who acts without intelligence, freedom of action or intent does not act with malice. On the other hand, one who acts without intelligence, freedom of action or fault does not act with negligence. Article 12. Circumstances which exempt from criminal liability. The following are exempt from criminal liability. 1. An imbecile or an insane person, unless the latter has acted during a lucid interval. When the imbecile or an insane person has committed an act which the law defines as a felony, delito, the court shall order his confinement in one of the hospitals or asylums established for persons thus afflicted, which he shall not be permitted to leave without first obtaining the permission of the same court. 2. A person under 9 years of age. 3. A person over 9 years of age and under 15, unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provisions of Article 80 of this code. When such minor is adjudged to be criminally irresponsible, the court, in conformity with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. For any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. 5. Any person who acts under the compulsion of an irresistible force. 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. 7. Any person who fails to perform an act required by law, when prevented by some lawful or insuperable cause. In exempting circumstances, there is a crime committed but no criminal liability arises. Technically, one who acts by virtue of any of the exempting circumstances commits a crime, although by the complete absence of any of the conditions which constitute free will or voluntariness of the act, no criminal liability arise. Burden of proof. Any of the circumstances mentioned in Article 12 is a matter of defense, and the same must be proved by the defendant to the satisfaction of the court. Paragraph 1. An imbecile or an insane person, unless the latter has acted during a lucid interval. Imbecility distinguished from insanity. This paragraph establishes a distinction between imbecility and insanity, because while the imbecile is exempt in all cases from criminal liability, the insane is not so exempt if it can be shown that he acted during a lucid interval. During lucid interval, the insane acts with intelligence. An imbecile is one who, while advanced in age, has a mental development comparable to that of children between 2 and 7 years of age. An imbecile within the meaning of Article 12 is one who is deprived completely of reason or discernment and freedom of the will at the time of committing the crime. People v. Amble, citing People v. Formiganes. To constitute insanity, there must be complete deprivation of intelligence, or that there be a total deprivation of the freedom of the will. The Supreme Court of Spain held that in order that the exempting circumstance of insanity may be taken into account, it is necessary that there be a complete deprivation of intelligence while committing the act, that is, that the accused be deprived of reason, that he acts without the least discernment. or that there be a total deprivation of freedom of the will. People versus Formiganes. Insanity exists when there is a complete deprivation of intelligence in committing the act, that is, the accused is deprived of reason, he acts without the least discernment. Because there is a complete absence of the power to discern, or that there is a total deprivation of freedom of the will. People versus Puno, citing earlier cases. Also, People versus Magellano. Thus, mere abnormality of mental faculties is not enough, especially if the offender has not lost consciousness of his acts. At most, it is only a mitigating circumstance. Article 13, Paragraph 9. Procedure when the imbecile or the insane committed a felony. The court shall order his confinement in one of the hospitals or asylums established for persons afflicted, which he shall not be permitted to leave without first obtaining the permission of the court. But the court has no power to permit the insane person to leave the asylum without first obtaining the opinion of the Director of Health that he may be released without danger. Chinafu versus Conception. Who has the burden of proof to show insanity? The defense must prove that the accused was insane at the time of the commission of the crime, because the presumption is always in favor of sanity. People versus Boscos. Sanity being the normal condition of the human mind, the prosecution may proceed upon the presumption that the accused was sane and responsible when the act was committed. The presumption is always in favor of sanity and the burden of proof of insanity is on the defense. People versus Aquino, citing cases. How much evidence is necessary to overthrow the presumption of sanity? The wife of the accused and his cousin testified that the accused had been more or less continuously out of his mind for many years. The assistant district health officer who, by order of the court, examined the accused found that the accused was a violent maniac. The physician expressed the opinion that the accused was probably insane when he killed the deceased. The total lack of motive on the part of the accused to kill the deceased bears out the assumption that the former was insane. People versus Boscos. In order to ascertain a person's mental condition at the time of the act, it is permissible to receive evidence of the condition of his mind during a reasonable period both before and after that time. Direct testimony is not required, nor are specific acts of derangement essential to establish insanity as a defense. Mind can be known only by outward acts. Thereby, we read the thoughts, the motives and emotions of a person and come to determine whether his acts conform to the practice of people of sound mind. To prove insanity, therefore, circumstantial evidence, if clear and convincing, will suffice. People versus Benoan. Insanity at the time of the commission of the felony distinguished from insanity at the time of the trial. When a person was insane at the time of the commission of the felony, he is exempt from criminal liability. When he was sane at the time of the commission of the crime, but he becomes insane at the time of the trial, he is liable criminally. The trial, however, will be suspended until the mental capacity of the accused be restored to afford him a fair trial. Evidence of insanity. The evidence of insanity must refer to the time preceding the act under prosecution or to the very moment of its execution. If the evidence points to insanity subsequent to the commission of the crime, the accused cannot be acquitted. He is presumed to be sane when he committed it. U.S. versus Guevara, People versus Fausto, People versus Puno. If the insanity is only occasional or intermittent in its nature, the presumption of its continuance does not arise. He who relies on such insanity proved at another time must prove its existence also at the time of the commission of the offense.